Hi everyone, my name is Alexander Zalivako, and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching. We would look today into the application of international economic sanctions with respect to the trade in Russian crude oil and petroleum products. And the purpose of the presentation would be to demonstrate the complexity of the issues involved when international economic sanctions aim to regulate a complex and all-encompassing business process like trade in Russian crude or petroleum products, as well as to demonstrate the complexity of legal solutions which are deployed by various jurisdictions when faced with this sort of objective. And more specifically, we would look into the briefly economic background to the trade of Russian crude and petroleum products and those challenges which this background poses to the development of a sanctions program. Then we would look into two types of sanctions which are deployed against Russian crude and petroleum products, namely embargo types of sanctions and price cap sanctions. And we would conclude the presentation by some practical advice to the operators, what they should not and should not do in the current business environment. On this first slide, I present two graphs to set up the economic setting to this presentation and to demonstrate 2 points. The first point is the relevance of Russian crude and petroleum products for the international markets. We can see that Russia is the third largest exporter after the United States and Saudi Arabia, by far exceeding the following exporters, which underscores the importance which Russian crude and petroleum products, which are refined from the crude or are exported to Russia, the international markets, play for energy stability in the world. This is one of the most important considerations that any sanctions program needs to take into account when trying to regulate the trade in Russian crude and petroleum products. On the next graph, I want to demonstrate that most of the Russian crude and petroleum products, potentially counterintuitively, is traded by sea. So it's the seaborne oil and petroleum products which generates most revenues and which is most relevant for stability of international prices. And it is for this reason that when we will go on in this presentation, most of the restrictions actually apply to seaborne oil. That's the main source of revenues, and that's why most of the regulations are focused on this product. So with this complexity in mind, it's clear that an efficient sanctions regime shall be nuanced and shall take into account various objectives. And there are two with respect to the trade of Russian oil and oil products. The first one would be similar to any other restriction on trade in Russian commodities, which is to reduce the revenues of the Russian state. And from that perspective, total restriction or quarter restrictions would seem to be most appropriate. But in terms of oil and petroleum products, it's important to consider the relevance of them for global market. And for that reason, the sanctions program set the second objective, which is basically to ensure the ongoing availability of those products to the market outside of certain specific jurisdictions. And the purpose of this is to ensure energy stability and no substantial effect on the price calculation. So these are two, to a certain extent, mutually exclusive objectives. And from that perspective, many complexities of the current sanction regime can be better understood. Another point to consider is that the interests of multiple third-party jurisdictions, sometimes critical interests of national energy security, are involved in any restrictions which may be imposed by international players on Russian crude and petroleum products, given the relevance of the relevant volumes for world economy. Some countries, for example, Mongolia, are almost entirely dependent for historical reasons on Russian crude and petroleum products. And it's impossible for those countries, given, for example, that Mongolia is a landlocked country, to diversify to other jurisdictions. Same applies not only to Mongolia, but to certain countries within European Union as well. For example, Slovakia and Hungary will be the main examples of those countries which continue to export Russian crude on the basis of that being an integral part of their national energy security. It's also important to recognize that multiple third-party jurisdictions use Russian territory for the purpose of transportation of their crude oil or petroleum products and bringing those to international markets. It would be equally unfair if a program which is targeting Russian origin crude would adversely affect those third-party jurisdictions. So an efficient sanction program should take the interests of those countries into account and make sure that they are not adversely affected on the one hand, but on the other hand, certainly that the permission to transport third country origin crude is not used as the tools of circumvention. The final point to consider is that certainly Russian crude can be refined into petroleum products. Substantial resources may be invested in this process. And the question arises as to what the treatment should be of those refined products. We would see in the course of the presentation that the answer to this question has been different over the last 3 years, and we would see how it evolved. So given this complexity of the matter and various interests which are involved, it is unsurprising there are multiple restrictions in place. And we would start by discussing one set of those restrictions, which I term as embargo type of sanctions, which can also be called ban introduced by individual jurisdictions with respect to the import of Russian oil and oil products. Here I give an example of the United States, where the relevant embargo or ban for the import of Russian oil and oil products was introduced by Executive Order 14066. And we can see here that the territorial scope of this ban is the territory of the United States. So the ban does not purport to regulate the access of Russian crude to international markets. It just relates to the territory of the United States, where the relevant import of oil and oil products is prohibited to the extent it's of Russian origin, and any services which are related to this type of prohibited activity are equally prohibited. Here we can see a similar ban of the United Kingdom, which is formulated in very similar terms. It affects only to those imports which purport to bring oil to the UK market, and the prohibition applies both to the import itself and certainly any related services. And similar to the United States embargo, the prohibition relates only to oil of Russian origin and does not relate to any third-party oil or oil products which are merely transferred through the territory of Russia. The same theme, worded in very similar words, applies also to the European Union, which has introduced also embargo with respect to the Russian crude and petroleum products. Nevertheless, given that the economic realities of the European Union are very different from the United States and of the UK, which have historically not been exporters large exporters or even to a certain extent competitors of Russian oil and petroleum sector. The European Union had very extensive relationship and trade in Russian oil and petroleum products. There are various pipelines linking Russia to various jurisdictions in the European Union, which were supplying crude and petroleum products to the European market. So the dependency is more substantial, and accordingly, the embargo is subject to certain restrictions, subject to certain exceptions. The most notable of which is the supply of Russian crude by pipelines to certain European Union jurisdictions. Originally, many jurisdictions relied on its exemption. Over years, certain jurisdictions like Germany, Poland, recently the Czech Republic have no longer need for the application of those exemptions. And accordingly, as of today, the exemption remains relevant in the European Union only for two countries, Hungary and Slovakia. There is another exception which provides for a force majeure scenario if for any reason the supplies of crude by pipeline is interrupted, then the countries which are relied on the relevant exemption may also start importing the relevant amounts of crude or petroleum products by sea. So we can see that in principle, the same rules apply, but they're more nuanced given the interests of various countries and the more close historical trade in these products between the European Union and Russia. So if we try to summarize the key elements of embargo across jurisdictions, and I just gave 3 examples, but these are by no means the only countries which impose certain type of embargo on Russian crude and petroleum products. There are other countries which follow, in essence, the policies of the main jurisdictions which I've discussed. For example, Switzerland would be another example of the country following the sanctions of the European Union, or Australia, New Zealand would be the examples of the countries following the general oil and oil products embargo. So to summarize how embargo operates, the following key elements may be identified. First of all, the embargo affects only imports into the relevant jurisdictions. So it doesn't purport to go above and beyond the boundaries of the relevant states. The embargo relates to import transactions themselves and any ancillary services necessary for those import transactions. In general terms, technical assistance, brokering services, financial services would be also covered. Third country oil or petroleum products merely transiting through the Russian territory are generally not affected. Some jurisdictions require that Russian individuals have no ownership interest in those products as an additional requirement. Certain technical issues which may affect the transportation related to the residues of Russian oil, which may be used in the same tanks which are used to transport third-party oil, is duly taken into account by the relevant sanctions laws, or whereby in general the principle is that to the extent that residue amounts cannot be extracted from the relevant tanks or containers without damaging them, then they do not contaminate the legitimate import of the third country oil. And the final big question, which has been also addressed in the relevant legislation, which relates to refining Russian crude in third-party jurisdictions, which do not impose embargo, has also been answered in the relevant legislation. Historically, the answer has been that to the extent the relevant Russian crude or petroleum product is subject to so-called substantial processing in the third-party jurisdictions. By substantial processing, generally was understood the change of the tariff by an 8-digit number. Then this product can be then imported into the jurisdiction which follow embargo against Russian oil and oil products on the basis that this type of substantial processing makes these products of the origin of the new jurisdiction. So the connection with Russia is broken as a result of that processing. The recent change in the European Union embargo, which was introduced on the 18th of July 2025, with the so-called 18th sanctions package against Russia, made a radical change to this general approach, whereby the Russian crude, which is processed in third-party jurisdictions, which do not follow the embargo types of sanctions against Russian crude. So the resultant petroleum products may no longer be imported into the European Union, except if the relevant jurisdiction is the next net exporter of crude oil, which gives certain flexibility, maybe to certain jurisdictions, but certainly would then make it impossible to refine Russian oil, for example, in jurisdictions which have been doing this recently, like India, for example, for further export of the petroleum products to the European Union. It is notable that the exception talks about refining crude, and on its plain reading seems to exclude the situation when actually petroleum products are used as the base to refine them into new type of petroleum products. So that seems to be falling out of the scope of the prohibition. It remains to be seen, however, whether the European Commission, given the general purposive interpretation of the EU sanctions, will give it a broader clarification, which would appear to be quite likely, given the overall purpose of this restriction. So now we would move to the second category of sanctions imposed against Russian crude and oil products, so-called targeted price cap sanctions. It's a good example for us to see how both embargo and target sanctions operate hand in hand in the sanctions regimes of various countries when the overall objectives of the sanctions program are much more complex and go over and beyond the simple prohibition. The price cap sanctions were introduced with the purpose to achieve the second objective of the economic sanctions imposed against Russian crude and petroleum products, which we discussed at the beginning, namely to ensure that there is an uninterrupted flow of those products to the market, global market, and accordingly the price for those products and for those products and services which rely on crude or petroleum is not affected. With this in mind, the regime in essence and the sanctions in essence can be summarized as follows. To the extent EU operators, any kind of operators, being traders, insurance companies, owners of ships or vessels, or operators of vessels, banks providing financing or processing other transactions. So to the extent EU, US, UK operators are involved in the trade of Russian seaborne oil, they may continue their involvement, provided that the relevant transactions with respect to Russian origin seaborne oil or oil products are concluded at or below the relevant price cap. So in essence, the obligation is to ensure that the price cap is respected, and to the extent it is respected, the relevant transaction is permitted, and any ancillary services with respect to the transaction are also permitted. We note several points about these sanctions. The first one is that they relate to seaborne oil and oil products. So technically speaking, the trade by pipeline in between Russia and third countries or by road, for example, in case of Mongolia, is not restricted. in any sense or form by this type of regulations. So only seaborne oil transactions are affected. It doesn't matter who the parties to that transaction are, so it can be trade between a Chinese seller and a Vietnamese buyer in Russian origin crude. Key point is what is the subject matter of the transaction and not who the parties are. As the trade relates to seaborne oil, the restrictions operate from the time the relevant product is loaded on board a vessel, and then they come to an end when the relevant product is released for free circulation in the relevant jurisdiction. Currently, there are 3 caps which are relevant. The first cap applies to trade in crude. That has been $60 per barrel. To the extent the price under the relevant contract is in different currencies, the conversion has to be made in accordance with the rules published by the relevant competent authorities, and in general terms, based on considering the weighted average of the relevant exchange rate between 2 currencies published by the central bank of the relevant jurisdiction. The price cap for Russian crude has been recently revised down, and it will be $47.60 starting from the 3rd of September 2025. The relevant announcement was made on the 18th of July by the European Union Council and the UK OFC. Likely the United States will also follow the general reduction of the threshold, as well as any other countries which coordinate Russian sanctions, meaning G7 countries, together with Switzerland and New Zealand. Then there are 2 additional caps which have not been revised. One applies to those oil products which are traded with premium to crude, and the other one which trade with discount to crude. So these price caps, as we can see, are not permanent. They are revised on a case-by-case basis, depending on the fluctuation of the price of oil in the international markets, and accordingly, it's important to verify what the actual price cap is. We would conclude by giving some advice for the operators which arise from the sanctions. One is that it's important to follow the embargo rules applicable in your jurisdictions or oil price cap. And in general, obviously, you're not permitted to provide any services or enter into any contracts which would be in breach of those restrictions. And to the extent you discover a breach underway, then obviously the way forward would be to immediately suspend or terminate, depending on the contracts, the provision of the relevant services, report this to your regulators, and seek legal advice as to how to proceed in those specific circumstances. To make sure that your claims are substantially and adequately managed, it's important to have the relevant sanctions clauses in your contracts, which, to the extent you're exposed to the risk of being subject to sanctions relating to the embargo or price cap, which we discussed, should specifically refer to those elements in national legislation. It's important to note that the sanctions set out very detailed and highly regulated process of attestation certificates, which the operators shall receive from those parties which have direct access to prices. Calculation of prices for oil and petroleum products may be a complex exercise. Often the prices are floating, linked to a specific base with a certain discount applying to the base, which would make it very difficult to ensure that the restrictions are complied with. So to the extent the relevant parties have no extensive knowledge, they may rely on the attestation process, but the process is complex, will depend on how far is the relevant party from the price formation exercise, and certainly does not mean that the relevant parties shall discontinue their standard due diligence with a view to verify that the attestation does not just result in some kind of general paperwork. Last point to note is that given the complexity and importance of the sanctions with respect to the Russian oil and oil products, the record-keeping requirements with respect to the relevant station certificates and supporting documents should be strictly followed, and if not, may expose the operators to additional liability, as well as certain specific reporting requirements are imposed on the operators. By way of example, in the UK, each transaction which is subject to the restrictions shall be reported to the regulator by the relevant UK operators. I trust that you found this presentation useful, and thank you very much for watching.